Good evening, friends. As we always keep on saying that after the COVID and during the COVID, we have been doing various sessions. And as we have always seen that youngsters especially are quite fascinated to understand the Arbitration and Conciliation Act 1996. And when we speak of Arbitration and Conciliation Act, Section 34 is one such section, which is quite has a good interplay for the purposes of understanding this Arbitration and Conciliation Act as to where the arbitral award can be challenged, the various aspects in respect of as to whether the party was under incapacity, whether the arbitration agreement was invalid, whether it was against the public policy, etc., etc. And in the today's session, we have Ashish Chopra, a senior advocate from Punjab and Haryana High Court. We requested him that if he could share his insights, because he has created his niche, especially in respect of the commercial law, and the Arbitration and Conciliation Act would fall within the trappings of the same. He's a younger brother of mine, and though he has a quite engaging engagements after this session, yet he agreed because he said that sharing is caring. And thank you, Ashish, for accepting our invite, and over to you. Unmute.
Thanks, Vikas. Rather, it would be my pleasure to be here. Thanks for persuading me to give an insight and share whatever limited wisdom I have. I always believe that it's good to share whatever experiences you get and you make in life. Without much ado, I'll straight away come to the topic, the practical aspect of Section 34 of Arbitration and Conciliation Act. Well, there are two aspects of it. One is theoretical, one is practical. So I'll deal with both because they're all intertwined. Section 34, there's much has been laid in respect of 34 by the Honorable Supreme Court. The law has seen various twists and turns, right from Renu Sagar going to ONGC, and then Western Gecko, then thereafter Associate Builders, then of course Sion, and then there is an aspect of doctrine of severability, the valid part to be severed from the invalid part of the arbitral award. And then we have Balasamy, which holds the field now, the 5 judges bench. So I'll be dealing and touching all the aspects, but in a very, very, I would say, a simple way, not making it too complicated, which actually to my mind, it has already been. So coming to Section 34. Section 34, I would like to divide in 3 parts. One would be, of course, 34.1, where the grounds have been laid down, 34.1 and 2, and 2A, as to on which grounds you can seek setting aside of the award. 34.1 talks about recourse to a court, that you have to make an application to a court for setting aside the award. 34.2, of course, enumerates the specific grounds on which you can seek setting aside of the award. And of course, 32 capital A also, 34.2 capital A, sorry. It also talks about as to one of the grounds of patent illegality. And the second part, which I would be dealing with, which is an offshoot, which in fact would be contained in one of the proviso also, the doctrine of severability. And the third part would be the limitation part, which you'll find in 34.3. So coming to the first part, Section 34.1, of course, it says that the recourse has to be taken to a court. without taking a recourse, one cannot have a award set aside, because award can't be something in rem. It's between two parties. It's a dispute redressal forum, an alternate dispute redressal forum, which the parties agree to refer their dispute to. So therefore, you have to take a recourse to a court for setting aside the arbitral award. That would be one. And it says that it has to be in accordance with 2 and subsection 3. So therefore, 2, as I had already stated, 2 lays down the specific grounds on which you can have the award set aside. Now, 2, there is a distinction. There is 2A and there is 2B. Now, 2A, which takes about and says that the party making the application furnishes proof. I'm just trying to draw a very fine distinction between 2A and 2B. 2A says that the party making the application furnishes a proof in respect of the grounds 1, 2, 3, 4, 5 mentioned therein. And B says the court finds that 1, 2, 3, 4. I'll elaborate on those grounds a little later. But there is a fine distinction. What I was trying to make was is that 2A talks about furnishing of a proof by a party, whereas B makes a departure. One doesn't have to furnish a proof in respect of the grounds which come under B. It says if the court finds that the award is liable to be set aside on the grounds mentioned in B, then of course you don't have to furnish proof in respect thereof. And why so? Because if we look at the grounds in A, they say the party making the application furnishes a proof that, I'll just go through it very, very briefly and swiftly. It says a party was under some incapacity. Of course, if a party is under any incapacity, one has to furnish a proof as to show how that party would be under incapacity. Second, the arbitration agreement is not valid under law to which the parties have subjected to it, failing any indication thereon under the law for the time being in force. So obviously, one has to prove that arbitration furnishes proof arbitration agreement is not valid. It's all factual going out there. Third, the party making the application was not given proper notice. Of course, again, this one has to prove that one was not given a proper notice for that matter. Fourth, the arbitral award deals and contains decisions on the matters beyond the scope of the submission. Today, this is a very interesting, in fact, ground on which one can seek setting aside of an award. This is where a dispute has arisen. Suppose a dispute entails 3 claims or 4 claims, or as a consequence of thereof, you are entitled to claim 5 claims. However, you refer only 2 claims out of 5 claims to an arbitrator. And arbitrator, apart from deciding those 2 claims which you have referred to out of the 5, decides even 2 more claims, which according to him could be the claim that you could have sought for, but you didn't seek. So there the arbitrator has traveled beyond the scope of the submission because you never submitted that claim before the learned arbitrator. You chose to submit only 2 claims, so the learned arbitrator is bound to decide only those 2 claims. So what is submitted before the learned arbitrator cannot wander outside the scope of submission. So this is a very interesting, because many a times the award is set aside on this ground itself. So this would be 4th point. And where this doctrine of severability, which is an offshoot, which I'll come to it later, is a proviso of this to this very subclause. It says, provided that if the decisions on the matters submitted to arbitration can be separated from those not so submitted, only that part of the arbitral award which contains decision on the matters not submitted to arbitration may be set aside. 5th, the composition of arbitral tribunal and arbitral procedure is not in accordance with the agreement. So for all these grounds, one needs to furnish a proof. Like I was talking about, if you have not submitted a claim, so of course you furnish a proof that this is the proof where I was entitled to, or the other person who's challenging the award will have to furnish a proof that one was entitled to, and one could have sought other claims but failed to seek those claims, and the arbitrator has still granted those claims which had not been submitted for adjudication before the arbitrator. So now this is 2A. Now we come to 2B, where the court finds that, now this is the departure I was talking about. One doesn't have to furnish a proof, the court needs to find. And in what manner and how the court would find, that of course has been elaborated through various precedents, over a period of time, as the Honorable Supreme Court has settled. Now it says the subject matter of dispute is not capable of settlement. That would be one. The arbitral award is in conflict with the public policy of India. Now, of course, everybody knows that public policy of India, it had been in contention in so many judgments, where they have first elaborated the scope, then restricted the scope, and now after the amendment in 2015, there is an explanation which has been added, which says, for avoidance of any doubt, it is clarified that the award is in conflict with the public policy of India only if the making of the award was induced or affected by fraud or corruption, or was in violation of Section 75. Two, it is in contravention with fundamental policy of Indian law. I'll elaborate this later on. It's been already held in one of the judgments, that is Sanyong, where what would be the fundamental policy of Indian law as relying upon associate builders. I'll come to it later. And third, it is the conflict with the most basic notions of morality or justice. Now that explanation has been given so that there is no doubt. They wanted to do away with certain observations and findings rendered in one of the judgments rendered by the Honorable Supreme Court before the amendment of 2015. That would be associate builders, when they had relied upon Western Gecko and had explained Western Gecko in a fashion which the legislature thought cannot be. So therefore, they explained it, and later on, those paragraphs of associate builders, the judgment rendered by the Supreme Court, were done away with. I'll come to it and I'll refer to it. But this is the explanation which had been given regarding the conflict with public policy of India, that it is in contravention with the fundamental policy of Indian law and in conflict with most basic notions of morality or justice. Now, again, explanation 2 comes in. This is where I was talking about they wanted to do away with that finding of associate builders, where they relied upon Western Gecko and elaborated it to say that it's a judicial pronouncement. For the avoidance of doubt, the test is to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. 2A, an arbitral award arising out of the arbitrations other than international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Now, there is a proviso to it, provided that an award shall not be set aside merely on the ground on erroneous application of law or by reappreciation of evidence. Now, elaborating this, so therefore, as we look at it, 2A, 2B, 2B, and if you would in fact see the series of the judgments in line, they mostly relate to Section 2B, because most of the awards which come under challenge under the scanner of the court under 34, they come under 2B. They're very rare cases in my limited years of practice. Whenever I've seen so, there could be 1 or 2 grounds, but mostly and by and large, whenever the award is set aside, they are set aside on the grounds when the court finds that the grounds appearing in 2B are in existence. So now coming to that, I'll make it more simpler now. There are 3 or 4 judgments. If I feel, if one would want to raise a challenge, the practical aspect of it. Of course, Section 34, the law is well settled, is not a court of appeal. This I needn't elaborate much. This is settled that there is no appreciation or reappreciation of evidence. So one has to be, uh, if an award is challenged in the court has to work in the guarded rails of this section 34. The contours of jurisdiction of the court exercising powers under 34 are limited to the extent of the grounds raised in 34 itself. So therefore, one, we should understand it's not a court of appeal, so there can't be an appreciation or reappreciation of evidence. Nonetheless, the Honorable Supreme Court, once having said that there can't be reappreciation, appreciation, say so and laid down, in so many so terms that if the award is and does not consider any evidence or is based on no evidence or overlooks a material piece of evidence, then of course the award on the face of it would be taken to be perverse and patently illegal. I'll rely upon certain judgments where they say so. So therefore, on one hand, of course, they say there is a distinction between reappreciating and appreciating an evidence, and there would be another thing to say that, well, the award does not take into account the evidence which has been led or does not take account into the evidence which may not have been led, I mean, sorry, or gives an award on basis of something which is not even there is no evidence, or overlooks some material evidence. So in that case, the court which is exercising jurisdiction under 34 is not appreciating or reappreciating the evidence. It's saying on the face of it, on the face of the award, if the court finds that this is the basis or this could have been the basis which has not been taken into consideration, one, or the court finds that there was a material evidence available on record for the learned arbitrator to have arrived at a decision, that material evidence has not been taken into consideration, then of course the court has the power to set it aside. Now, all these grounds have been elaborated. I needn't take only two judgments, as I said it, not many judgments. One is Associate Builders. If one was to see it, that's the Honorable Supreme Court. I'm sure everybody would know, whosoever has been dealing with arbitration in Section 34. Associate Builders versus Delhi Development Authority. There are certain paragraphs of those that would be 18, 27. It considers the line of all line of the judgments in line where Renu Sagar, ONGC, Hindustan Zinc, and all those judgments, even Western Gecko for that matter, had been considered, and has laid down, in short, I would say that where the award is perverse or irrational and is based on no evidence, then of course it would fall under the realm of Section 34. Secondly, it says justice and morality. This is where the fundamental policy of Indian law, when it came to be decided in Associate Builders, they had said as to what would be the justice and morality, that it shocks the conscience of the court, that the award is such that it would shock the conscience of the court that such an award could not have been passed. So this is where Associate Builders came in to say, then this is a ground for setting aside the award. Now, interestingly, after the Associate Builders, when the one of the questions had arisen, then amendment had come in 2015 as to whether it would be prospective or retrospective, and Sanyong judgment, the Honorable Supreme Court says, well, it would be prospective. Of course, 34, any application under Section 34 filed after 2015, that is 23rd October 2015, when the amendment came in, that would be governed by the amended provision of 34. So then the Honorable Supreme Court went ahead to discuss as to what would be the grounds in light of the amended provision of 34 for setting aside the award. And the Honorable Supreme Court considered Associate Builders. In fact, I would rather say that they took lead from associate builders to say that the grounds which had been considered by associate builders in one head may not be appearing in that head, but could be taken to be a ground in the other head. What I'm saying is, if I would read certain paragraphs of Sayong judgment, they said that if in case earlier there was a ground which was appearing under the head of fundamental policy of Indian law or otherwise public policy of India, which had been done away with, that may not be a ground available to you under that head, but certainly that would be a ground available to you as the award being patently illegal. So there are certain aspects which Sanyong judgment had dealt with while taking into consideration all earlier judgments, including associate builders, which would make a very interesting read if one was to read paragraphs starting from 34 to 41 and 42 of that very judgment. So one would find where it says, Sanyong again says, where the arbitrator wanders outside the contract and deals with the matters which have not been submitted, of course, would be a ground. Then again, the Sanyong again reiterate what has been stated in associate builders, reiterated that where there is a ground of perversity, then of course that would also be a ground for setting aside the award. The associate builders, in fact, if I may just read one paragraph very interestingly, it did away with two paragraphs of associate builders, that is paragraph 28 and 29. And they said, and it was held therein, that it is clear that the public policy of India is now constricted to mean, firstly, that a domestic award is contrary to the fundamental policy of Indian law, as understood in paras 18 and 27 of associate builders, or secondly, that such award is against basic notions of justice or morality, as understood in paras 36 to 39 of associate builders. Explanation 2 of to section 34 2b2, which I had read earlier, and explanation 2 to section 48 2b2, which we are not concerned with, we are only talking about 34, was added by the Amendment Act only so that Western Gecko, as understood in associate builders and paras 28 and 29 in particular, is now done away with. So that's where I said that the Western Gecko, as understood by associate builders in paragraphs 28 and 29 of the associate builders, they have been done away with. So therefore, where I may also touch the associate builders in paragraphs 28 and 29 had said that there should be a judicial approach. So therefore, those paragraphs had been done away with by Sanyong in paragraph which I was just reading in 36. Now, one more aspect where I said that they, from one head to the other, when I was referring to that, that's one of the paragraphs where it says it is important to notice that the ground for interference insofar as it concerns interest of India has since been deleted and therefore no longer obtains. Equally, the ground for interference on the basis that the award is in conflict with justice or morality is now to be understood as conflict with the most basic notions or morality of justice. This again would be in line with paras 36 to 39 of associate builders, as it only such award that shocks the conscience of the court that can be set aside on this ground. So therefore, they have like they said, that mere contravention of substantive law of India by itself is no longer a ground available to set aside an arbitral award, para 42.2 of associate builders, however, would remain for if an arbitrator gives no reasons for an award and contravenes section 31.3, that would certainly amount to patently illegal on the face of the award. So they had said, well, if those were deleted, they had retained all those grounds which were there in associate builders, barring one or two grounds. So what I was submitting was is that, of course, associate builders, which still holds the field, I would say, Sanyong, and which has been followed subsequently in many of the judgments, say Patel Engineering, PSA Sickle, Delhi Metro, There are a whole line of judgments which follow. But basically, the law as it would stand settled, in a simpler way, in a practical aspect, I would say that it's a very limited ground. What happens is, in a practical aspect, if I may share this, I don't know whether I should be sharing or not, but sometimes, and I'll share it with my experience also, there was one of the observations made by one of the courts, and there was an argument raised by the other side saying this award has been passed by a three-member arbitral tribunal who are retired judges of the Honorable Supreme Court. So, as such, it should not be interfered, or the court should be loath in interfering in. Well, the practical aspect, since we are on to the practical aspect, if we were to look at the practical aspect, well, this could be an argument to intimidate, I would say, with due respect and utmost humility, to say that please do not set aside the award, or this cannot in no manner can fall within the realm of the grounds, the contours of 34. But in my respectful submission, I would always say, before the court, that one doesn't have to get persuaded, or I would say, intimidated by the fact that the award is by somebody who had been an honorable judge once, in higher in hierarchy. One has to see the award on the face of it. If it falls within the four corners, I would say, of Section 34 of the grounds, it is liable to be set aside, and it must be set aside. Because as such, the award, the very object, no doubt about it, there is a judicial interference. Section 5, there are a lot many judgments which says that the scope of judicial interference has to be very, very minimal, has to be less. And that's why Section 5 was introduced, to say that unless and until that part, notwithstanding any law, anything contained anywhere, there has to be there cannot be any judicial interference unless and until the part one provides for it. But I say that no doubt about it, the object of the act is 1996 speedy justice. Well, I don't know about the costing part. I rather refrain myself in saying whether the object has been met or not, that it's less cost, or it's cost effective. But I would say still, even if the object is speedy justice, but that does not mean that an award cannot be said to be perverse, or the arbitrator or the arbitral tribunal giving an award could not have erred in law. The award cannot be perverse. So therefore, I would rather uh, assign or give a wider meaning to these very grounds of 34, to say that one will have to see the award, one will have to go into all these aspects to see whether the award is liable to be set aside or not. One cannot shut oneself, or a party out, to say that, well, I'm not exercising jurisdiction as an appellate court, so therefore I will not look at the award at all. Uh, I would say that approach shouldn't be there, because after all, there are grounds, and the grounds have been, a time and again, the Honorable Supreme Court, while stating that the scope is limited, has in fact given a lot of room to the court to have the award set aside. And I feel that these grounds are good enough for the award, and would rather cover everything in it for the award to be. It's only a matter of discretion to the court, if the court would want to exercise or not. Uh, I mean, sometimes there is a jugglery of those words, to say that, well, this one cannot go into, or this one can go into. But I feel that if we were to restrict to the grounds, and as has been elaborated in these judgments and precedents, it would give enough room for the court to set aside the award which is perverse on the face of it. Now, having said that, There has been a question regarding the severability of the award, which had been, of course, engaging a lot of concern and which have now, of course, been put to rest by Honorable Supreme Court in Gayatri Balasami's case. 5 judges bench, of course, there's a majority of 4:1. So Justice Sanjeev Khanna, speaking for the majority, has given a finding therein. And doctrine of severability, of course, there has been analysis in different parts as to what would be, in what cases the court can remand, in what cases the court can set aside. Of course, I've just spoken about when the court can set aside the award. There's no dispute about it. The grounds are there. And that's why the second part, when I'll be dealing with the doctrine of severability, this is where it becomes a little tricky for the court, I would say, because that may not engage much. We have precedents for setting aside the award that may not engage us much, all of us, because we have precedents to say as to on what grounds it can be set aside. But so far as when it comes to as to whether a part of it can be set aside, whether a part of it can be remanded or can be modified. So now I would say, well, the power to sever, as has been held by the Honorable Supreme Court, is inherent. Of course, the greater power would include the lesser power also, as the court has held. That's the doctrine which they have followed. So they have bifurcated into three aspects, I would say. One is setting aside the award and setting aside the part of the award. That would be simple if I look at it. If the award could be severed, if a part of the award, the invalid part, could be severed from the valid part, setting aside the invalid part, there cannot be any dispute regarding it. So far as the modification part would come in and remand part, there is a very fine distinction which again the Honorable Supreme Court has carved out. They say that the modification part and the remand has to be looked at, that the remand could be only on a very specific aspect. The remand cannot be, if there is an omission, if there is a substantial illegality or otherwise, you cannot remand it. You can set it aside. And if that part is not separable or intertwined with the other, then of course you can set aside a part of it. But if it is not separable, it cannot be separated, then you have to set aside the entire award. But remand, when we talk about remand, when it comes to when the power is given under 34 for remand, that remand can only be on specific issues or aspects. That can't be on the ground that, well, there has been an illegality. There has been a ground for setting aside the award, but however, I remanded back for the arbitrator to correct it and then send it back. That can't be, to my understanding and limited understanding I would have. They say that it can be only on the specific aspect where the court probably finds that on this specific issue, one could send it back and get an order or the award from the learned arbitrator or a reconsideration thereof. But so far as the grounds for setting aside and the 34 is concerned, that cannot be a ground for sending or remanding it back. And one more aspect, while we're talking about remand, there was a judgment initially passed where they said that remand could only be made once there is an application which has been made. Again, Balasamy has also now cleared that air, also said that, well, one could even make an oral request for a remand. And so much so that Balasamy goes on to say that it is not only 34, in 37 also, which they say that it's an appeal against this thing, order passed under 34. They say, I'm not talking about the scope of 37 as of now, the limited scope or otherwise, but they say that in 37 also one could make a request for a remand and that can be entertained. So that's a practical aspect where the judgment of the Honorable Supreme Court had come in and interpreted, it was quite pragmatic and practical approach and interpretation given by them to say that it could be severed and set aside, and it could be severed and modified. Now, when it comes to modification, they say that of course one would have the lesser power, which would be subsumed in the bigger power which one has, but that modification also could be to a limited extent, because you are not sitting as a court of appeal. You cannot modify something otherwise which will look as if you are acting as a court of an appeal. But today, as I look at it, there is a very fine distinction as to when one is wanting to modify the award. But that also has been put to rest by the Honorable Supreme Court, as to they have laid down as to in what and which cases one could modify the award, and to whatever extent one can modify the award. So therefore, this would I would say Balasamy is the judgment as of now, which would give you an insight regarding the remand, regarding the modification, regarding the setting aside of the award after a part of the award, the valid part from the invalid part. One is this judgment. So everybody who's wanting to understand 34, I feel these are the as on date, I would say these are the three judgments one should read threadbare if one is to get insight about how the 34 works. That is Associate Builders, Sanyong, and Balasamy, because Balasamy takes into consideration M. Hakim and all other judgments. So one needn't go into all other judgments to understand the concept of 34, the grounds, the limited scope, the severability part, and the remand part, and all these aspects. Now, there is one, of course, a limitation part under 34. That also the law is well settled now. I needn't say much on that. Subsection 3 of 34 provides for that one has to file it within 3 months, and of course a grace period of 30 days and not thereafter. So the again Honorable Supreme Court in various judgments have held also not thereafter would mean that you cannot bring in an action once that period has expired. So that would be a death knell for a person who is wanting to challenge the award. So 3 months, in fact, very interestingly, I came across a judgment where they say 3 months would mean 3 months. They say the legislature used the word 3 months and 90 days. It didn't use the word 3 months and 1 month. So therefore, when we are using 3 months, it would be 3 English calendar months. It's not you work out 30 days or 90 days that ways. It doesn't. So it's 3 months and 90 days. So of course, and not thereafter means that once that period expired, you cannot. Certain exceptions have been given. That is section 14. One would come in, where you have been pursuing a remedy in a wrong forum. So the judgments have made an exception that period would stand excluded, because of course you can't seek a condemnation of delay, but section 14 of Limitation Act would stand on a different footing altogether than section 5. So that would be the limitation part. And practical aspect I've already stated earlier, that how the courts would be loath to interfere in the award, but one will have to really make out a case under 34, relying upon these judgments and the grounds which have been laid down in these precedents. If you are able to bring in your case within 4 corners of these very grounds and the precedents, because if you were to read the ground as such, you may not be able to understand as to what would be the fundamental policy of Indian law, etc. But they have been elaborated and settled by the Honorable Supreme Court. So these are the judgments which I just mentioned, which will give you an insight as to what could be the grounds on which you can seek setting aside of the award. That would be it, I think, in case if Vikas would have anything to.
Yeah, only Ashish, since I know that you are running out of time, one question which I would like to understand from the perspective of youngsters: can courts review or reappreciate evidence while deciding the challenges under Section 34?
No, as I had said, because earlier also the court cannot appreciate or reappreciate evidence at all, because the law is well settled. The court is not sitting as a court of appeal. It is only a court of appeal where we talk in civil sense of the matter that it's a continuation of proceedings. So therefore, the court can appreciate and reappreciate the evidence. So here it's a limited ground which have been given for the court to interfere so far as seeking setting aside of the award is concerned. And that law has been well settled that the court cannot appreciate or reappreciate. That's why I made a distinction. I said, well, there would be a distinction of appreciating and reappreciating an evidence and setting aside an award based on no evidence or having overlooked a material evidence. So when a court finds that the award is based on no evidence or has overlooked a material evidence, that would be not to, or that would be not even akin to say that it's appreciating or reappreciating evidence.
Yeah. The last question we will be taking: what are the key strategic considerations you feel that one should keep in mind while framing the objections under Section 34?
See, I feel any matter for that matter, when you just see what the law settle is. If you are able to, when you draft 34, I feel that once you've gone these judgments and the law settled by the Honorable Supreme Court as interpreting 34, you'll have to make your case fall under those very exceptions, those very grounds, as has been settled by the Honorable Supreme Court. So when you draft 34, you'll have to see as to how the award could be said to be perverse, how the award could be said to be based on no evidence, how the arbitrator, or how we could, or one could say that the arbitrator has wandered outside the contract, the terms of the contract, because after all, the arbitrator is somebody who is to work on the terms of the contract. If the parties have submitted themselves to the arbitrator, they would want him to see their contract and adjudicate upon the disputes. However, if he has wandered outside the contract or outside the submission, as I had said earlier, if there are 5 claims, you have submitted 2 and he has granted the third, which you have not even claimed, or you have not even submitted that dispute before the learned arbitrator. So therefore, you have to, when you draft 34, it's very simple. You have to see that in these parameters, whether you are able to get your case fall within these parameters or not. If it does, then it will be very easy for you to convince a court that these are the parameters in which your case falls and you can get an award set aside. And of course, you can get it set aside. See, sometimes you need to give that handle to the court. You can't, sometimes what weighs or what could weigh in the mind of the court is that if there is an award, how, and because of one of the grounds or 2 of the grounds which one say that one could be a ground to set aside the award, the entire award would be set aside, then of course that doctrine of severability would come in. Then of course, when you have to draft, you have to take it into consideration that whether what you are challenging and that part of the award could be severed or not severed. So these are the important aspects and key aspects one needs to take into consideration while drafting 34.
Yeah. So thank you, Ashish. And those who have stayed connected with us can watch the previous webinars by us. And on Tuesday, we will be having a session on agencies under the Contract Act by Dr. Vandana Arora, the chairperson of the Law Department, Punjab University. So do stay connected with us on Sunday. And thank you, Ashish, once again.
Thank you so much.